So today I wanted to discuss the $100,000 fee that's tied to the H-1B applications. And there's maybe a missed opportunity based on a misunderstanding of who the $100,000 applies to and who it doesn't apply to. So let's get into that with this video. My name is Rahim Dhanani. I'm a U.S. immigration attorney, and I've been practicing U.S. immigration law for more than 25 years. The $100,000, first of all, it's getting challenged. There are multiple lawsuits that have been filed. One of the bigger ones was from the U.S. Chamber of Commerce, and they did lose that initially, but it's being appealed. And I think the appeal is being heard in February or March of 2026. So right around the corner, and who knows, the whole thing could go away. There's also another lawsuit over the $100,000 that's been filed by 20 different states attorney general. And I think there's also a third group that's filed a lawsuit as well. So multiple lawsuits out there. Who knows, the whole thing could go away. And sometime this year, hopefully before the lottery season even starts. And if that's the case, then, it's good for everybody that's involved in the H-1B process. The other thing I wanted to discuss is that if the foreign national is already in the U.S., and if they're filing for a change of status, a extension of status, or they're trying to amend their status, then the $100,000 fee does not apply to these people. So for an employer, if you're looking at a F1 student who is on OPT and you're thinking about sponsoring them for the H-1B, they would be changing status in the U.S., presumably. And so if they're changing status in the U.S., then the $100,000 fee does not apply to those candidates. So you could go ahead and file for the change of status if they get through in the lottery. And then when that gets approved, the proclamation goes further and says if they were approved in the U.S. and they have that 797 approval notice, then they can go overseas and actually get the H-1B visa and come back in. But I highly recommend they do not go to the consulate or embassy overseas to get that visa processed, because they're going to probably hit severe delays in getting the visa actually issued. So the better way to go with that is you would just do the F1 OPT change of status to H-1B, and then you just have the employee stay in the U.S. until the whole visa situation gets sorted out overseas. But I just wanted to make that clear to people that, you can still get this change of status done for people who are on OPT, and you would not be subject to that $100,000 fee. And that's a big deal for a lot of people, obviously, because that's a lot of money. But also, as a company, you don't want to miss that opportunity to get somebody who has a lot of talent and that is going to really contribute to your company, and just lose them because of a misunderstanding about the $100,000 fee and who it applies to. I hope that's helpful. Talk to you later. Bye.